Welcome you all to the lecture series on corporate law. In this lecture, we will be discussing on the terminologies and important concepts in corporate law. Those are shares and debentures. We see the subject of shares and debentures in different perspectives. Initially, from the perspective of commercial language or the language of the business personalities, and we also look into the legal definition of the shares and debentures. As we all understand, the very fundamental premises of corporate law and the corporations depends upon the share capital, because the company which is incorporated under Companies Act raises its own capital, and the capital is being divided into the shares. Now let us see the provisions of corporate law for some point of time, maybe from here after another 10-15 minutes. We will see how the company law defines. Then we will also see the provisions which are there under the business language or the business terminologies. Now, according to the Companies Act, Section 284 of the Companies Act, share means share in the share capital of the company and also includes the stock. Now the fundamental question will come: what is meant by capital? What is meant by share? Capital has been divided into the two types. The first type is equity capital. Second is debt capital. Under the equity share capital, you can have equity shares, then you may have preferential shares. In the debt capital, you can have the debentures or any hybrid instrument, the nature of which are the convertible natures. So the capital, the terminology of the capital, because we require a capital to commence the business of the company, and the company, the shareholders in the company brings the money. The money is being divided into the different shares. Because why the shares are being comes in the picture is that the corporate law, particularly when the company is being incorporated, we discussed in the first lectures and also in the one of the previous lectures in the Salman versus Salman case, the shares are being divided among the shareholders. It may be 2 people, it may be 7 persons. In the articles in the memorandum of association, it is written very clearly the authorized capital. Depending upon the capital, you are supposed to pay stamp duties. And capital is something which you are creating in fictitious terminologies. Some amount you may brought, some amount you may bring future. So therefore, you can start the business by 2 types of capitals. One is about equity capital and second one is about the debt capital. To put it a simple understanding, one is about a capital which creates debt, other one is capital which creates ownership, right? And other one is called loan amount. Then you can call about the own or ownership amounts. I put it in this way of understanding to our own easy way of subjects. If Mr. A, let us have an hypothetical problem. Mr. A, B, C, D, E, F, G, right? So you have the 7 persons incorporated ABC Limited, and they brought 1 lakh rupees into the capital, and they were looking for another 5 lakh rupees to start their business. And this 1 lakh can be divided among themselves by the shares, for this 5 lakh rupees, they can go to the public by issuing of either the equity shares by issuing of the debentures. In a simple way of understanding, after incorporation, a company can commence its own activities, one by borrowing of the money, the relationship of borrower and lender, and the second one is that raising of the capital with the relationship of equity as well as the ownership capitals. So try to understand why the share capital is very, very important. In the Companies Act, almost all 30 to 40% of company law, we talk about the shares, share capital and the capital markets as well as to the nature of the business. So it is very necessary to understand the types of the share capital as well as to the what are the capital it means. If you see the plain reading of the Companies Act, Section 2 Clause 84 of the Companies Act, it explains in a simple terminology, share means a share in the share capital of the company, though it makes a little bit of confusions because that's what I told. Share capital is one thing called equity capital, which you have equity shares and the preferential shares. When you talk about the capital, capital has two types. One is called equity capital, other one is the debt capitals. So that is why they says share means share in the share capital of the company, not under the debt capital of the companies. Let us move on and see how the company law defines about the equity share capitals. This is very, very important terminology from the legal perspectives, right? Under the legal perspectives, under Section 43 of the Companies Act, right? Companies Act 2013, the shares are being defined in the two categories. Then they also use a terminology called kinds of the share capital. According to the Companies Act, there are two types of or the two kinds of the capital where it says the share capital of a company limited by the shares shall be of two companies. That means if there is a company which is unlimited company and if there is a company which is limited by guarantee, this will not come into the pictures. So let us see if a company limited by the shares will have the two types of the capital. Number one is equity capital. Number two is preferential share capital, right? Number one is equity share capital. Number two is preferential share capital. In the equity share capital, there are two subclauses. If I put it in simple way, 1A and 1B. So totally we are having 1, 1A, 1B and 2. Put together, we can see in the Section 43 of the Companies Act, you find at least 4 types of the capitals, right? I am repeat again, equity share capital, preferential share capital, broadly two terminologies, right? That is very clear. And apart from the broader terminology, among the equity shareholders, there are two types of the classes. And if you put it called as equity with voting rights, equity with differential voting rights. Now some of you will have a doubt, what is this voting rights? What is this differential voting rights? In the Companies Act, we start reading with the concept, every equity shareholder has equal right to participate in each and every meeting. However, company law tries to differentiate under Section 43 that you can have equity shares with the voting rights, you can have with the shares with the differential voting rights. And to understand the voting rights and the differential voting rights, every reader, every investor should go through the articles of association of the specific company. If there is a specific company which defines or which divides the classes. This also we call in the later chapters of corporate law different classes of the shares, right? And the legal perspectives, now we see on subclauses, that is voting rights as per the agreement among the company and shareholders, differential voting rights as to the dividend, to the voting, or otherwise in accordance the rules prescribed may be in the Companies Law. Because in the present Companies Act 2013, you find in various places the language of or, right? I will write it, or otherwise. Or otherwise stands for the wisdom of the business community, or otherwise called wisdom of, right? Wisdom of commercial man, right? The people who are involved in the commercial business or commercial activity, they do have their own wisdom. They can prepare in the bylaws what are the types of or what are the rights given to the equity shareholders among themselves, how many rights have been divided, what type of right that everyone is getting. So in the initial chapters, I try to introduce to you, you have the equity share capital with the voting rights, equity share capital with the differential rights, that's what we call the DVRs, then equity share capital itself. Then other one is, like point number 2, is the preferential share capital. Now, preferential share capital, let us see the company law, how they try to define the meaning of the preferential shares. I will repeat again, equity shares with voting rights, equity shares with differential voting rights, and equity share capital. So you have the 3 subclauses which comes and part of the corporate law under section 43 clause A. Now see the section 43 clause number B, right? So preferential shareholders, right? Preferential shareholders means a preference with regard to the limited issued to the capital carries preferential right, right? Preferential shareholders has a right called preferential right with regard to the number 1, payment of the dividend and repayment in the case of the winding up. This is what they are talking about, the preferential right. Now let us take a small example, then try to understand what is equity shares, what is the preferential right. Say for example, in a company, there are 100 equity shareholders, right? 100 equity shareholders in a company, 100 people are there, and there are 50 preferential shareholder. Like, let us have an example like this, 100 equity shareholders with the voting rights, 50 preferential shares with the preferential right. Now the fundamental question will come, who has the right on who, how these rights are being divided. What happens is that in company law, these preferential people or the preferential shareholders has a right to mostly either fixed dividend and at the time of winding up, or if anything to be repaid to the shareholders, they get about the repayment, otherwise called repayment rights. Then suddenly the question will come, sir, in company law, whether equity shareholders are the main holders of the company or preferential shareholders are the real owners of the companies. Without any confusions, to make very clear, equity shareholders with the voting rights are the real owners of the company. Equity shareholders with the voting rights, they have the right to decide the dividend and they have the right how dividend can be given to preferential shareholders. So it is established principles in corporate law always that the equity shareholders will have edge, will have a carry right over a preferential shareholders. Then the other question will come to all of us. When we call them as a kinds of share capital, why this difference is given? In practice, what happens? Equity shareholders want a capital in the company through equity, not by the borrowings, through the equity investments. Therefore, they try to collect the money through preferential shareholders with a guarantee that you are getting a fixed dividend. You are also going to get preferential right over others. Then the company will have an advantage. The advantage is that the capital will come into the company, shareholders will come to the company. However, the shareholders who come inside the company, they don't have right to participate in each and every meeting of the companies. The preferential shareholders have no right to participate on each and every meeting of the company. Only they have a right in their agendas with regard to the dividend, with regard to the repayments. The advantage of the preferential shareholder is that shareholders would be very happy because the amount is being clear. They are going to get a fixed dividends. So company law says equity shareholders and the preferential shareholders. So equity shareholder has been defined under company law. Equity shareholder means which is not a preferential shareholder. Preferential shareholder means a company issued by the shares has a preferential right, which is meant by the payment of dividend, which is meant by repayment in the case of winding up. Then another question will come to all of us. Then what is the meaning of equity shareholder? Let us have a simple understanding. Equity shareholder is equity shareholder is the one which is not the preferential share capital, right? Then equity shareholder has been divided by the various characteristics. Try to understand the definition of equity shareholder is being defined with the certain characteristics of the companies. So therefore, equity share means equity shares which is not a preferential share capital. Preferential share means they have the preferential right, number one, with regard to the dividend, number two, at the time of repayment, in the case of the winding up, what have to be paid, this is the number two, and number three, they have the right to a limited extent and with the capital and not entitled to preferential right aforesaid, respect of capital to their own subsidiary matters. So preferential shareholders may not have all the rights to participate in the affairs of the company because they have only two important rights, that is about the dividend. Now one more point which I want to try to inform. The people who invest in a company through the share capital, the returns will come in the nature of the dividends. In the case of equity shareholders, the dividend is not fixed. Sometimes it may be various from time to time because it is the equity shareholders who have the voting rights decides how much dividend has to be given. So therefore, there are two types of the shares. One is equity share capital, other one is preferential share capital according to the section 43 of the Companies Act. Kindly remember, section 43 of the Companies Act talks about kinds of the share capital. So section 43 of the Company Law talks about the kinds of the share capital, which is equity share capital and the preferential share capital. In the equity share capital, with voting rights and without voting rights. With the preferential share capital, we have the other type of classifications. Now, let us move on. What are the shares, how the beneficial owner comes? And here I just want to inform the other terminologies in corporate law. It's called the beneficial owners. Maybe I will take on the beneficial owner at some point of time. Since the concept has come, generally what happens, beneficial owner is the person name whose name recorded with such a depository. Let me have a simple understanding where all will try to understand. Say for example, Mr. A wishes to purchase the shares from, say for example, Reliance IPO, right? For example, if the Reliance has come in IPO, Mr. A wishes to purchase. So A has opened the first step. You open a demat account, put some capital. Through an IPO, you are trying to send your request or you try to put your bidding process through the demat account is opened. Then you have another person is called as the broker. The broker means the open which you have opened as the SBI or ICICI. For example, take for example SBI Capitals Limited is a broker which works for the purchase of the securities, and they also act as sometimes depository participant, and the Reliance issues the shares. If there are 1 lakh people applied for the shares, they allotted for 10,000 shares. These 10,000 shares names are with the depository. There are 2 depositors in India. One is NSDL, other one is CDSL. So the shares are being created a different denomination number by the depository. So the shares were held with the depository. After held with the depository, then later they will transfer to the Mr. A. If the shares are held for some period of time with the depository, we call it as shares held with the depository is called as the beneficial owner. So beneficial owner is that my name is entered with the depository. Once it is being transferred to my name, held with the depository name, then thereafter I have to apply to the company, enroll my name in the register of what is called shareholders. Once the name is entered in the register of shareholders, I become the shareholder of a company and also a member of company. Don't get confused. If your name is the depository, that you don't have the rights. It is not like that. Even if the name is the depository, you are considered as a beneficial owner. Beneficial owner is also having all equal rights like a member who is having in the company's law. Because member has been defined under the section 2 clause 55 of the Companies Act. When you see the member means, you talk about subscribers of MOA and who are names are entered in the register of shareholders, right? Register of shareholders with the company. And the third category, if the name is the beneficial owner and they also comes as the members. So there's a depository who keeps the denominations, who creates the specific number for each and every share. Once the share is being created, share has a different number, share has a different denominations. So therefore it is being held with the depository for some time and later it is being considered as the transfer to the shareholders. Now let us move on to the other important concept that is called nature of the shares and debentures. The shares or debentures, other interest of any member in a company, is a movable property and transferable in the manner which is provided under the Articles of Association, right? Shares are considered as movable property. Now try to remember the legal background. The transfer of movable property, you also find the rules of Sale of Goods Act, right? And shares are considered as a movable property. Whatever the transferability comes, then it called as movable properties. I'm again repeating, if somebody will ask you tomorrow, what is the nature of the shares, whether shares can be called as a property, whether shares can be transferable, then you can tell shares are the movable property, shares are transferable. I will be recording another lecture on transfer of the shares as the movable property. Therefore, I am not going in detail on transfer of movable properties. Number, as just I told you, every share is being distinguished number given by the depository. So you have the shares which have the different denomination numbers, because nowadays all our lives are connected to a number. Say for example, we are all having the unique identity numbers. Directors are having director identification number. People are having the PAN number, and shareholders are getting distinct share numbers, share certificate, shares numbers allotted by company. Why it is like that? After 1996, all public listed companies, they issue the shares in the demat form. That means all shares are in the electronic form, right? All shares are now in the electronic form. So when the shares are in the electronic form, these are being recorded and maintained by depositories. Those are CSDL, NSDL. So once the shares are being created as a capital, then these numbers are given to the shareholders. That number automatically will come to your Demat account. Demat account stands for the dematerialization of securities, because under the Depositories Act, all shares should be in the Demat forms. Now let us move to the other concept under the Companies Act. This is the certificate of the shares. A certificate is very important. When the certificate is issued under common scale, where the company has appointed company secretary or a director, so certificate of the shares is an evidence that you have the share in a company, right? Once the company issues the shares, the certificate of the share is an evidence of the company. In the case, if a company has defrauded the issue and they also created some manipulation, these people belongs liable to under 447. In the Companies Act, you find very frequently for any fraudulent transactions, for any fraudulent activities by the company, they always talk about the punishment which is under the fraud. One, you have the penal provisions, that is called about the rupees 10 crores, whichever is higher. Every officer who is in default shall be liable to be in action under 447. Officer in default, this is also a very broader term in company law. The law defines who is an officer in default. Because when we talk about officer in default, the question comes whether CEO is an officer in default, or managing director, or company secretary, or you can say the CFO, or an employee. So company law has listed some of the people under the definition of officer in default, but the person who is actually holding the post, the person who is actually holding the responsibility comes as an officer in default. I will be recording another lecture on this concept called, there is a huge discussion on who is the KMP, that is called key managerial person, and who is also officer in default. I will record one of the lectures on liability of the persons. Maybe in further lectures we will discuss, because the present lecture is only devoted to understand shares and debentures and what are the types of the shares. Voting rights is very, very important, because when we are talking about the voting rights, this provision directly comes in relation to the section 43 clause A subclause 1, right? Under section 43 we talk equity shares with voting rights. Now voting rights are divided here, right? For your understanding, I am putting section 47 of the Companies Act. Every member of a company limited by shares holding equity share capital shall have the right to vote on every resolution placed before the company. Every member of the company who is a member of company, kindly refer when you get a time, is under section 2 clause 55. There are three types of the people. Number 1, subscribers of MOA. Number 2, whose names under the register of shareholders. Number 3, if the name is with the beneficial depository as a beneficial owner, all becomes a member, right? Even if the name is with the beneficial depository as a beneficial owner, they do comes as a member. Try to understand every terminology or every legal term in company law has lot of in-depth analysis. Just reading on periphery of a subject may not help you when you try to practice law, when you try to interpret the law in real life. So voting rights are given under section 40, and also they talk about subsection 50. And this is very, very important. Voting rights only decides the decisions of the company in a way called who has the right to vote or who has the main right to participate. So everyone try to understand in real sense that who has the actual voting and how this voting has been divided. So this is actually comes in a practical way of aspect. what is meant by voting rights. There is also a concept called agreements decides on voting rights. As of now, try to understand, right? Equity shareholders with the voting rights subject to the provision of section 47. In the future lectures, we will have the elaborate discussion on this particular concept. Variation you don't require as of now. Now let us talk about another important concept is called debentures. Debenture means debenture stock, bond, any other instrument of a company evidencing a debt where constituting a charge of on the assets of the company or not, right? Debenture is a document, right, or instrument. I am explaining this particular legal terminology for you. Instrument in law. You may have a doubt. Sir, can you give any example of legal instrument? Legal instrument for debentures. I can tell you. Mortgage deed. Then loan, where the company borrows the loan by keeping some charge on a property. We call it as loan document also is a instrument. Because you find the peculiar drafting of company law, the legal instruments is called in evidence of a debt. In evidence of a debt, you have lot of legal documents which show that someone owes a debt. Then you call as the mortgage deed or the loan document, etc. and all. So debenture is also a document which comes under the definition of the debt capital, and under the debt capital they have the what is called about the management of the debt. This actually I will have one more lecture which is planned in the future, Sahara case. We can discuss about the types of the debentures as well as the how the law talks about the optionally convertible. In this class, I just referring the concept. Debenture means a document, evidence of a debt, where the corporations or companies borrows the money by giving up the legal document, then we call as the debentures. Now I am talking to the two more types of the capital. This is actually a business language. In accountancy, chartered accountants, company secretaries, cost accountants, even the lawyers, when we read the balance sheet of the company, right? When we read the balance sheet of the company, when we read the MOI of the company, you find authorized capital, otherwise called as a nominal capital. There where they say the capital which is written in the memorandum of association is called as the authorized capital. Called up capital means a part of the capital which has been called for the payment. Generally what happens in the corporate law, the practice, for example, Mr. A purchases one share, ₹10, right? In corporate law, they may ask you on first call ₹5, then they say afterwards ₹3 and 2. This is what we call calls. ₹10 of the face value of the shares are generally divided 532. Sometimes company may ask you to pay, company may ask Mr. to pay 10 rupees at a once. If 10 rupees are paid completely for one share of 10, this is called as fully paid shares, right? If Mr. A purchased one share in a X limited company, the value of the share is 10 rupees. If Mr. A paid 10 rupees and company is called for 10 rupees, this we call it as fully paid shares. If the company collects only 5 rupees, this is called about the paid up capital. We have other 5 rupees comes as the uncalled capital, otherwise called unpaid capitals. This is what the practice of corporate law happens when the company calls for the shares on that. And in accountancy background, these terminologies have been elaborately explained. So this class, I try to introduce on the Section 43 of the Companies Act, Section 47 of the Company Law, Section 2 Clause 55 of the Companies Act, right, on the members and on the voting rights. Then we have also seen about the Section 2 Clause 484 of the Companies Law, followed by Section 2 Clause 30 on debentures. I try to introduce to the basic concept of corporate law, that is meaning of the share, types of the share capital, meaning of the debentures, and the voting rights as well as different voting rights. In the next class, I will talk about the transfers and also the other concepts related to the share capital. Share capital is one of the very practical subject, a very huge subject. I will try to divide a 40 minutes lectures as much it's possible. I will try to introduce the subject on the different concept in the next day and for other coming lectures. So I thank one and all for listening very patiently. Kindly make any comments if you are having. So thank you one and all again. Take care. Bye.